Women's rights are human rights are women's rights. Today, the 10th of December, it's the United Nations Human Rights Day. A president of the People's Tribunal, the CEDAW People's Tribunal, the Convention on the Elimination of All Forms of Discrimination Against Women. In 1986, this country ratified CEDAW. In 2004, the country signed the optional protocol to CEDAW. That means that under the Convention on the Elimination of All Forms of Discrimination Against Women, women from this country who have claims of discrimination that would arise under CEDAW, under the Women's Rights are Human Rights rubric, if they've exhausted all remedies in this country, able to go to the CEDAW committee if they have lost in the courts of this country, heard by the CEDAW committee, and they're upheld, then this country must listen. It's not obliged to overturn its wrong decision, but it is obliged to listen. What we want to come into play, according to the recommendations of the President's report of the CEDAW People's Tribunal, is that this country should honour its obligations under CEDAW because of having signed and ratified that international convention. It is making a commitment to entering that law, the principles of CEDAW, into domestic law in this country. The United Kingdom has not done that yet. Very piecemeal, it's introduced legislation about equal pay, which really has not made a great deal of difference to women's income, to women's wage rights. Of course, the Equality Act of 2010 has some waving in the right direction, but it is certainly not enough. And the CEDAW committee has recognised that, in that within the last few days, the CEDAW committee, that is the United Nations Committee addressing or under CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, that committee has said to the government of this country, the United Kingdom, that the United Kingdom must stop lagging behind, stop dragging its feet, and come into the 21st century, which it ought to have done, come into the 20th century when it signed up to this CEDAW convention. But the committee has said in this letter within the last few days, sign up, honour your obligations, honour your commitment, that the United Kingdom is not entitled to ratify CEDAW, having signed it several years before, and then simply sit there not implementing it, not introducing it into domestic law. So the principal recommendation of the President's report from the CEDAW People's Tribunal is that this country, the United Kingdom, must introduce a Women's Bill of Rights. That Women's Bill of Rights must incorporate every principle, every provision of the Convention on the Elimination of All Forms of Discrimination Against Women. That Women's Bill of Rights must also incorporate the updates that have come since 1979, when the original convention was drafted, all the updates that the CEDAW committee has made in its deliberations on the operation and the application of CEDAW. So, principle one, this country, Prime Minister, Parliament of the United Kingdom, get a move on, if I am entitled to use a somewhat colloquial expression. The women of this country are entitled to a Women's Bill of Rights. that acknowledges women's rights are human rights are women's rights. That acknowledgement will come about only by this government introducing into the Parliament of the United Kingdom a Women's Bill of Rights. If the United Kingdom Parliament lags in its obligation to do that, it will find itself pushed to one side by the devolved authorities of Scotland and Wales, which are already on their way to introducing bills of rights, women's bills of rights, so that the women in Scotland and the women in Wales can have the protection and the advantage and the advancement that would accrue to women under domestic law framed in CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. This is the principal proposal, the principal recommendation of the Tribunal, that a Women's Bill of Rights be introduced domestically into the law of this country to cover England, Scotland, Wales, and Northern Ireland. Now, under the recommendations of the President's report, if the United Kingdom Parliament does, as it is obliged to do, introduce a Women's Bill of Rights, then that would not preclude Scotland, Wales, and Northern Ireland from doing so also, though they would have to be consistent with the United Kingdom principles, the CEDAW principles, because there are other nations that also have states or provinces or lands where there are domestic laws that cover women's rights as human rights, and they operate alongside the national law, not overturning it, but operating in accordance, for example, with entities that are registered within that jurisdiction alone. And there is no problem with having a United Kingdom Women's Bill of Rights and working alongside that United Kingdom Women's Bill of Rights, Scotland, Wales, and Northern Ireland also having their own legislation covering women's rights as human rights, but they cannot derogate from the principles of the United Nations Convention on the Elimination of All Forms of Discrimination Against Women, with all its updates, because they could not bring in legislation that undercut women's rights that are written into a Women's Bill of Rights that is the United Kingdom Bill of Rights. Now, that of course is not enough, because what we know and what we learned through the CEDAW People's Tribunal hearings is something that's sadly extremely obvious, and that is there is a desperate need for education of the judiciary, education of lawyers, whether they're practicing as barristers, as solicitors, whether they're working in the academic sphere. Too few acknowledge and recognise the principles and the practices required under the Convention on the Elimination of All Forms of Discrimination Against Women. Some of them, I hasten to say, although I'd prefer not to be in a position of having to do so, too many of them don't even know that CEDAW exists. And yet they sit on courts throughout this nation, throughout the United Kingdom, pronouncing on issues relating to the law, of course, and not being aware that women's rights are human rights and human rights are women's rights. Therefore, one of the major recommendations of the President's report is that they all need to be educated that there is an essential element relating to all of this, and that is that when the Women's Bill of Rights is brought in, is passed by the United Kingdom Parliament, it must include a provision which says that it is mandatory for members of the judiciary and the magistracy at all levels to receive education and training on an initial and regular basis about what these rights are, what women's rights are, what the women's rights are that are human rights that accrue to women and to which women are entitled. Now, when I say mandatory and when I say initial and regular, what I mean is it's no good to have a one-off training session, a one-off education session for the judiciary, for the magistracy, for the practicing profession, and then say, right, been there, done that, that's fine. They know all about the Women's Bill of Rights and what its aims are, what the principles are, and how it ought to be put into effect. Because this is dealing with centuries of undermining women, not regarding women as human, considering that women are not persons, and denying human rights to women, denying that women's rights are human rights, and denying that human rights are women's rights. This problem will not be overcome in a trice, in a jiffy. It won't be overcome by one training session on the Convention on the Elimination of All Forms of Discrimination Against Women, by one training session, one educational program on the Women's Bill of Rights. It must be mandatory training, it must be initial training, it must be regular training. But we're not going to stop at the magistracy, the judiciary, and the practicing profession. Every member of Parliament must undergo training and education in women's rights as human rights and human rights as women's rights. If there are members of Parliament in the United Kingdom Parliament or in the devolved assemblies who are pronouncing upon legislation, who are saying yay or nay, who are going into committees and proposing amendments to legislation, or if they're going about their constituency business and they do not know about the principles that need to be addressed and recognised and acknowledged fully in terms of women's rights, then they can't be equipped to do their job as representatives of the people. Representatives of the people must be aware that women's rights are human rights are women's rights, and therefore there must be mandatory education and training for members of Parliament. And we're not stopping there. Those who seek to represent the community in any elected office, for example, as local councillors, they too require this training. And therefore, this is an essential element, an essential recommendation of the President's report arising out of the CEDAW People's Tribunal. There are other matters, of course, in relation to this Women's Bill of Rights, because in the hearings that were before the People's Tribunal, the hearings of the 21st, 22nd and 23rd of June in the year 2021, many experts in their field, women and some men, appeared giving evidence about being in practice and appearing in courts or tribunals, or working in research positions or in academia, or working at the grassroots level in women's services. And every one of these women and the few men who appeared who care about women's rights as human rights as women's rights. Every one of them, out of their expertise, out of their practical work, out of their academic work, out of their theoretical work, were cognizant of faults in the system that demand rectification. For example, one of our witnesses gave evidence of her practice in the family jurisdiction. And in the family jurisdiction, according to our witness, who is, of course, a very well-equipped individual, an individual of great expertise, that's why she was giving her evidence to the People's Tribunal, this witness said that one of the problems in the family jurisdiction is that if issues that relate to violence in the family arise, for example, rape, marital rape. Now, marital rape is a crime and has been in this country since 1991. It took a very long time for the courts to actually recognise that the prior history was simply wrong and ought never to have been adhered to. The reality was that rape in marriage should have been a crime, recognised as a crime long before 1991. But there is a definition of rape in the Sexual Offences Act 2003. But this definition, now it's a definition in criminal legislation, but that doesn't mean it's a definition that applies only in that jurisdiction. That legal definition must also apply in the family jurisdiction. And yet, according to our witness, it's a case of make it up. Make up what rape is or isn't in the family jurisdiction, when in fact, the judiciary already has a definition of rape that it should be applying, a definition that has been set down by Parliament as what constitutes rape. It's not up to them to make it up. It's up to them to apply the law. So that's one problem arising, which indicates seriously that there's a need for training and education of all the judiciary in every jurisdiction. Now, it's no good for them to say, well, look, I'm practicing in the commercial field and really women's rights are irrelevant to the commercial field. Well, of course, then, if they're saying that, they simply indicate, I really hate to say it, and I do hope no judge says that, because it's indicating a supreme degree of, well, ignorance of what the reality is. Of course, women are impacted by commercial law, just as women are impacted by tax law. Women are impacted by land law. It's not that women are simply impacted by some limited area of law. And I'll give you an example where commercial matters do impact on women. It's not the only one, but I'm giving you an example. We call this sexually transmitted debt. This is terminology that came into being through the intellect of a barrister, Emma Swart, and a lawyer practicing as a solicitor, Jenny Lawton. They formulated this characterisation of the example, which I'll give to you now. A man who has a mother who is a widow and owns her own home wholly, fully. No mortgage, no debt on this house. It's fully free of all debt. He, of course, wants to perhaps enter into a financial agreement to buy a truck because he wants to go into the trucking industry. Now, you may be unaware, but these very large trucks in the trucking industry cost a great deal of money. In fact, they could cost as much as a modest home, or an immodest home for that matter. He needs to borrow money. And the finance provider, whether it's a bank or some other independent finance provider, says to him, you will need a guarantor. So what does he do? He thinks of his mother, and he goes to his mother, imploring her, "Mother, will you be my guarantor? I need to buy this truck. It's desperate. I have to go into the trucking industry. This is how I will make my career. This is how I will make my fortune. There will be no risk for you at all, Mother, because I will make all the payments on this loan agreement into which I'm entering with the finance provider. You will simply be signing on the dotted line, and it really won't mean anything. There will be no obligation for you at all." Now, Mother, of course, wanting to support her son, does sign on the dotted line. The finance provider doesn't provide her with the information she should have, that she's putting her house at risk, because the house is going to be the security that goes with the guarantee, that goes with the loan. And therefore, what happens is that I'm afraid the son does renege on the loan. He does fail to make the payments, and then her house will be taken in by the finance provider and she will lose it. That's what we call sexually transmitted debt, because the debt is being transferred to mother from son. It's an obligation that she's entered into because she cares about her son, but it's an obligation she's entered into because both the son and the finance provider have not been straight with her, have not advised that she needs independent legal advice. So that's just one simple example of where we can't say there are only a narrow area of laws that apply to women, or where the judiciary and the magistracy and the tribunal members need to be acquainted with women's rights as human rights. And let me just backtrack for one moment in speaking of the judiciary and speaking of this woman who signs his name on the document. Why does she do it? It's out of love and affection, wanting to support her son. But it's also that unfortunately, as women, we have sometimes been led to believe that our signatures don't really count. They don't really have a value. And why would it be that women are put into this position when in fact our signatures do count? And banks and finance providers want our signature on documentation when we're going to support somebody else's loan by guarantee. They want our signatures because they know that women are scrupulous, generally speaking, in repaying the debt. And the reason is that members of the judiciary for years and years brought down decisions in the 19th century into the 20th century saying women were not persons. And this wrong has been carried through the law in many ways. Women are now regarded as persons. A decision of the Privy Council in 1929 decided that, but it took a very long time for that to come about. Now, just to wrap up on a very quick note as to some issues also that are the subject of recommendations going along with the principal recommendation, which is a Women's Bill of Rights. There are many issues where the law does not work. And it doesn't work because it hasn't been written in language that actually recognises what the issues are that it should cover, number one. And number two, it hasn't been interpreted in a way that was intended to acknowledge and affirm women's rights. Let me give you two quick examples. One is abortion law. In England and Wales, abortion remains illegal unless it's conducted in accordance with the Abortion Act of 1967. The only operation in this country, in England and Wales, anywhere, that requires two medical practitioners to say that that operation should go ahead. This is a health operation. It's for the health of the woman concerned. Yet in this country, England, and in Wales, it will be an offence under Section 5 of the Abortion Act if the abortion, the termination of pregnancy, is not carried out in accordance with that requirement of 2 medical practitioners. Ironically, in Northern Ireland, it's no longer a crime to have a termination of pregnancy, but as we know from the witnesses appearing before the CEDAW People's Tribunal, abortion is not as readily available in that country as it should be, and as the CEDAW committee required that it be. That's an issue that needs to be addressed by a Women's Bill of Rights and by provision of proper services. But the irony here is, in England and Wales, that if one gets an abortion under this 1967 Act, you probably don't know, or many of you won't, that the doctor undertaking actually doing the operation is obliged to fill out a lengthy document that goes to the Chief Medical Officer of England or the Chief Medical Officer of Wales, depending on the country in which it's carried out, that gives all the private information about the woman who has simply undergone a health operation, an operation for the good of her health. It goes to this Chief Medical Officer. And it, as I say, it's this 2-page, at least, lengthy document of full details about who this woman is. That needs to be changed. And another change needs to be made in relation to rape law, which is not operating in the way that it should. It was right to redefine, to define clearly what is consent and what is not. But the problem with rape law now is that the entire concentration is on the woman and whether she consented or not, and a great investigation by way of cross-examination and so forth, or before that by police, and then the Crown Prosecution Service scrutinises her consent or not, when really the trial should be concentrating on what the man did, what was going on with him. He's the one that's the accused person, not the one who is coming forward as the principal witness or complainant in the rape case. And one of the problems with the Crown Prosecution Service that needs to be addressed too is that when it comes to cases that are dropped or simply just not proceeded with, what are the major areas of law of allegations of crime where that happens? It's flashing, it's criminal assault at home and other forms of domestic violence, and it's rape. Those are the 3 areas where the most dropping of prosecutions occurs. Now, I just want to really emphasise this about flashing. There's been a proposition in criminological circles that flashing really doesn't matter. This is where practically every woman in the world's had to put up with this at one time or another. A man approaches, opens his raincoat, and is naked underneath. And the woman has to, or the child, it's often a child too, has to actually endure this creature appearing in a raincoat, opening it with some sort of expectation that the viewer will be shocked, horrified, etc. Or perhaps admiring. He may be requiring that. Why? One wonders. But in those cases, the criminological view has been that it's not terribly important in any event and it doesn't lead to anything serious. Well, for a start, those who engage in that form of activity are very likely to go on and commit further crimes of a more impactful nature. When I say impactful, I'm not denying the impact of flashing, but sexual assault or even rape. But in itself, flashing is an assault and it needs to be treated in that way. It needs to be taken seriously. And the women who are children, the girls who are victimised in that way, need to have their equanimity, their rights affirmed and recognised without this glib notion that we can just dismiss the flashing cases, we, the Crown Prosecution Service, because they do not matter. They do matter. And the final point on this I'd like to make is that of terminology and language. And the President's report does make it clear that language is important. Glanville Williams, the doyen of the law from the University of Cambridge, once made the point that language is powerful, and the most powerful language is the language of the law. And I just address this as a final point, the language of the law. The terminology grooming needs to be readdressed. Grooming is applied when an individual, whether online or in person, leads a child or a young person into believing that they are cared for in a serious and conventionally affectionate way by an adult. And yet it's not about affection. It's about selfishness on the part of that person who wants to indulge themselves sexually by imposing themselves on a child or young person or exploiting them. Now, grooming is used because it's used saying that that action is a precursor to serious conduct, to the real conduct. There may be, of course, conduct that occurs after the grooming, but the grooming is real exploitation, abuse in and of itself, and it needs to be recognised in that way, not addressed as if it is a precursor to more imposing, more exploitative. It is exploitative, it's abusive in itself, and it needs to be recognised in that way. Let me say that there are many more recommendations in the President's report of the CEDAW People's Tribunal, the Convention on the Elimination of All Forms of Discrimination Against Women. What we need to acknowledge here is that if we are to get a Women's Bill of Rights to address equal pay, to address the pensions issue, women who've been deprived of their pensions, to address rape law reform, to address all those issues that are part and parcel of CEDAW, the recognition and acknowledgement of minority women's rights, Black and minoritised women, that Black and minoritised women are equally entitled to all the rights that men have, just as women who are not in the Black and minoritised category have an entitlement to recognition of all the rights that men have. What we need to do is remember that Black and minoritised women are denied their rights on this basis of being a woman and being from a Black and minoritised community. And that is absolutely essential to be recognised, the failures of the system there. But we need this Women's Bill of Rights, and the way that we will get it is by demanding it of our government, demanding it of our members of Parliament, and doing this by signing a petition, the link to which will be at the foot of this video, of this recitation of why we need a Women's Bill of Rights, this recitation of the President's report arising out of the CEDAW People's Tribunal hearings of June 21, 22 and 23. And I'm ending now on this note with a call to action. And the call to action is to all of us as women, and to those men who recognise injustice when it stares them in the face, as some men do. And that's why we have the right to vote, because the women demanded, and there were men who recognised the injustice that stared them in the face when women were denied the right to vote. And there are men in the community who recognise that without a Women's Bill of Rights, the injustices to women will continue. So our voice must be heard through this petition, through our lobbying of members of Parliament, and ultimately the demand must be made, and the demand is made to government, to Mr. Prime Minister. If you actually have any real consideration for the women of the United Kingdom, if you're capable of having any consideration for the women of the United Kingdom, you will immediately instruct Parliamentary Council to work together with CEDAW in law, the Convention on the Elimination of All Forms of Discrimination in law, the committee which is behind the People's Tribunal, the Parliamentary Council to work together with these women and men experts in order to draw up the Women's Bill of Rights, and then to present it to Parliament and take it through the Parliament with every member of your political party supporting it. And with every member, we demand of the opposition parties that they must support the Women's Bill of Rights too. So you can make your decision, Prime Minister. You can ignore this and you can be left with your feet behind in the dust, because the world is moving in this direction. The CEDAW committee has demanded in the last few days that the United Kingdom government act. We demand, as the CEDAW People's Tribunal, that you act. And if you don't act, Scotland and Wales will be ahead of you. But if you care about your position on the world stage, then we say, act now. A Women's Bill of Rights, women's rights are human rights are women's rights, and the women's rights, the human rights, need to be acknowledged, confirmed, and passed through the United Kingdom Parliament as a Women's Bill of Rights. Thank you.